Good morning, Your Honor. My Christian name is Jose and my family name is Elizondo. I am the bailiff today and
Okay,
respectfully ask some issues to raise.
wait, Mr. Elizondo, wait. Jose Elizondo, I show that you have one case pending, and that is expired registration. Do you understand that's the charge that is pending against you?
Yes, I understand, but
Okay,
respectfully,
sir. Okay, hang on. There's several steps we need to take over. Were you able to hear my explanation about defendant's rights and
Yes.
options that I went over at the start of court?
yes,
Do you have any questions about those rights or options?
yes.
Go ahead. What's your question?
Okay, respectfully, I haven't received my documentation that I requested in a timely manner to proceed today.
No. What is your question?
Outlined
No,
in the
no,
court
no, Mr.
form.
Elizondo, no. What is your question about the rights and options that I went over at the start of court?
I have no questions regarding that.
Okay, then to this charge of expired registration, actually, I'm going to stop and say, you mailed in payment.
I did.
You mailed in $3 and you have a balance due of $129. So with that payment of $3, we've already entered a plea of no contest for you because Texas law allows that to be entered for you. So we're set here to determine, are you able to make the balance of your payment by Monday, or do you need some time to pay that out?
Your Honor, respectfully, as a bailor and grantor, I've granted this court equitable title for settlement of any
No,
charges
sir, this
under
is a
doctrine
criminal
of
court. No,
trust
sir,
and merit.
Mr. Elizondo, this is not a civil court. There are no parties like that in this proceeding. You're a defendant, you're not a grantor. I'm the judge. And so that does not apply to this court. You may have read that might be something in a civil court. That does not apply here. So my question to you, sir, is since you've already mailed in payment and indicated a plea of no contest by mailing in a payment under Texas law, can you get the balance paid by Monday? Or do you need some time to pay that out? Or do you have a financial situation that you need a financial packet?
Your Honor, for the record, respectfully, I am a Texas common law free man. I do not participate in corporate Ponzi schemes that require me to have
This
registration.
is not that, sir.
and
This is not,
insurance.
Mr.
I do
Elizondo,
not
stop.
consent.
Mr. Elizondo, stop. This is not the time to make a statement. You see, we have like 12 other people who are set here. You're set on a criminal charge. This is not time for you just to go and make a statement about a civil matter that it is not set in this court.
So are you saying that I don't have civilian due process of law?
No, but this is not a civil matter. You're raising terms in regards to this as if this were like a civil lawsuit. This is a criminal charge where
It's
you've
not
already.
criminal, Your Honor.
Yes, it is, sir. This is a Class C criminal charge in Texas, displaying an expired registration. That is a Class C criminal charge, and you mailed in partial payment. So I'm trying to determine, are you able to make the rest of your payment by Monday, or do you need some time to pay it out?
I have the right to equitable title for this settlement or any charges on the doctrine of trust merge.
This is
And
not a matter. This is not a matter of a
respectfully,
title to a vehicle or anything like that, sir. You seem to be confusing some civil law.
Well,
with the pending
I have
criminal.
some confusion because on Supreme Court case law Murdoch versus Pennsylvania, they clearly state that you don't need registration or insurance for private personal travel, and I don't consent to any corporate Ponzi scheme.
Okay, well, this is nothing to do with a corporation. This is a Texas charge, and you've already mailed in a payment for this. So you've indicated a plea of no contest. Are you saying that you're not pleading that? Then why
Your
did you
Honor,
give them
as a
$3?
bailor and grantor, I gave
No,
this
no,
court
Mr.
equitable title for
Elizondo,
settlement
stop. Mr.
of
Elizondo,
any
stop.
charge under
Mr. Elizondo.
doctrine of trust merge.
Mr. Elizondo, stop. Why did you mail in $3?
Because as a bailor and grantor, I have granted to this court equitable title for settlement of any.
No, sir, we do not settle.
charges
And, sir,
under trust
Mr.
merge.
Elizondo, there's no party in a criminal charge that's called a bailor, and you cannot claim a position that is not one in this court.
Your Honor,
There's
are
no
you giving
status
me-
of bailor.
Are you giving me finance?
No, sir, listen,
Oh.
I need you to listen to me. I need you to listen to me. There's no status of bailor or grantor in this criminal court. You may have read some cases in regards to some other matter. You are a
can you give
defendant.
me-
No, Mr. Elizondo, you need to be quiet and listen. You're a defendant. You mailed in $3, which is partial payment of a total of $132. All right. Now, by law, when you mail in a payment, a plea of no contest is entered. All right. So my question to you was, when you mailed in the $3, was that your intent to make a partial payment? requesting a payment plan, or were you attempting to post a bond?
My intent was, like I said, I am the bailor and grantee. I have granted this court equitable title for settlement of any charges under doctrine of trust merge. That's my answer to your question.
Okay, that is not an answer that applies in criminal court. So based upon your payment of $3, the court has already entered a plea of no contest, and I'm going to order that you get the balance paid
Your Honor,
within
respectfully.
30 days.
Okay, Your Honor, respectfully, with those documents that you have, I didn't receive any documentation requested in a timely manner to proceed today. Outlining my
Sir,
full
sir,
intel
if
under
you-
Chapter 66 of Texas Civil Practice Code, which
Okay,
is
stop,
provable
Mr. Elizondo,
and
Mr. Elizondo, stop. The Civil Practice Code does not apply to this courtroom. This is the Code of Criminal Procedure applies to the criminal courtroom. So the Civil Code does not
But
apply.
I still have a civilian due process, Your Honor.
Well,
And I
yes,
have not
but
entered a plea.
you did by mailing it in. By mailing that in, that's entering a plea of no contest. You mailed in a payment of $3.
Your Honor.
You can
Like I
get the
said,
balance paid.
the reason why I did that as a bailor and grantor, like I stated multiple times, I've granted this court equitable title for settlement.
Okay,
under
Mr.
any
Elizondo.
document plus merge.
Mr. Elizondo, were you wanting to plead not guilty and request a trial?
No. Respectfully, Your Honor. Constitutionally, too. For the record, I am a Texas common law free man. I do not participate in any Ponzi schemes that require me to have registration and insurance. I do not consent quasi-jurisdiction. Respectfully, Your Honor, I plead for a civilian due process of law.
Okay, well, you're
Under
receiving.
Section 1, Article 10.
Okay, Mr. Elizondo, you're receiving the exact same due process that every other person who's appeared in this court has. And you have mailed in a payment of $3, and that payment is received as a plea of no contest.
Who is my accuser, Your Honor? Respectfully.
The state of Texas. That citation that you received, that is the accusation. And
Okay,
so,
I would like to go to trial for this.
So you're indicating that you wish to change your plea from no contest to not guilty?
Yes.
All right. And you wish to waive your right to jury trial, or do you wish to request a jury trial?
No.
So no jury trial. You wish to waive your right to a jury trial?
1 second, please. Never mind. Give me a jury trial, please.
So you wish to request a jury trial?
Yes.
And you will be representing yourself, or will you be retaining counsel?
Myself.
Okay. Do you understand that if you request a jury trial, if you're found guilty, in addition to the regular state court cost, there is an additional jury trial court cost that's assessed if you're convicted. Your case is going to be reset for a pretrial hearing. That is going to be for our May contest docket, which is at 6 p.m. on May 7th. Show your video.
I'm here.
Okay, thank you. So, Mr. Elizondo, you had a pretrial hearing earlier this year in May, and then at that hearing, you had indicated that you had mailed in a motion for a bond, and that was the only motion that you had, and we did not have that here. After the court, and we set your case for a jury trial on August 28th. Then after the date of your pretrial hearing, we received a motion in the mail stating defendant's Rule 91 motion to dismiss for failure to state a claim upon which relief can be granted. Mr. Bishop, have you received a copy of that motion?
Your Honor, and made a response.
Thank you.
I believe he's filed two motions. I've got a motion to dismiss and then a motion, no consent given motion.
Yes, that's correct. All right. So, Mr. Elizondo,
A no consent given motion. Oh, this is good. I haven't seen it yet.
if you wish to summarize your argument, you may do so at this time.
Yeah, I just want to know, do y'all enforce the Texas Transportation Code?
No, sir, we're not answering questions. You need to summarize your motion at this time.
All right, well, I just want to add to my motion that according to the Texas Transportation Code, Title 1, Section 502.003 clearly states it prohibits political subdivisions from requiring registration, and my violation was due to registration. So that's all I wanted to add, and I plead not guilty and for dismissal too.
Mr. Bishop, your response?
Yes, I addressed this in my response, Your Honor. The city of Dalworthington Gardens is the political subdivision of the state of Texas. And this registration requirement is not a violation of a city ordinance. There is no city ordinance that requires individuals to register their vehicles. That's state law. And so the defendant is incorrect in applying that statute because it's a state law violation, not a city ordinance violation.
The court has read the defendant's motion to dismiss, and I have read the state's response to that. And the court is denying the defendant's motion to dismiss. Don't see where you prepared an order for me to sign. Let me see.
I did not prepare one, Your Honor, but I will be glad to prepare one.
Okay, if you can prepare one, Mr. Bishop, I will get that signed. I'm writing a notation here. Motion denied. And then we have the second motion, defendant's no consent given. Mr. Elizondo, you may summarize your argument at this time.
Whatever I submitted is what I plead to continue with.
Mr. Bishop, would you summarize the state's response?
Yes, the state's response is in the state of Texas, driving is a privilege, not a right. And by exercising his privilege to drive on a Texas highway or street, he is subject to all rules of the road, statutes, and rules. For him to be subjected to jurisdiction when he has violated a state law. He's not being denied his rights. Driving is a privilege, and by driving, he subjects himself to the rules of the road and other state laws regarding driving.
All right, based upon the court has reviewed the written motion and response, motion by the defense, response by the state, has considered the arguments made here in court, and the court is denying the defense statement of no consent given to jurisdiction. Mr. Elizondo, your case is set for jury trial on Thursday, August 28th at 8:30 in the morning. That is when you need to be here. You have cited in some of your motions civil rules of procedure. As I have warned you before, I'm warning you again, the Texas rules of criminal procedure apply in this case. This is a criminal charge, and you need to follow the Texas rules of criminal procedure. You will be expected to follow proper courtroom decorum, and as you are representing yourself, you will be held to the same standard as if you were an attorney. You will need to be here at 8:30 in the morning. You will receive information regarding the venirmen, the potential jurors, and voir dire will start at 9 a.m. You will be given 15 minutes to ask relevant questions of the venire panel. The state will be given 15 minutes to ask questions of the venire panel. Each side is given the opportunity to make up to 3 strikes, and then we will proceed to the jury trial that day. Have any witnesses that you wish to call and any evidence that you wish to present here and ready when you get here at 8:30 in the morning. Do you understand, sir?
Yeah.
Okay. All right. Mr. Elizondo, is there anything else that you wish to put on the record at this time?
No.
Mr. Bishop, anything from the state?
Nothing further from the state, Your Honor.
Okay, Mr. Elizondo, you are released at this time. We'll see you here in person at 8:30 in the morning on August 28th.
Sounds good.
You are released at this time. We have one case that's the hearing for the motion for new trial on Jose Elizondo. Let me go ahead and call that. Mr. Elizondo and Mr. Bishop.
I'm here.
Okay, Mr. Elizondo. All right. Are you able to share your video, please, sir?
No, I'm not going to share my video
Why not, sir?
because I have somebody recording me from your YouTube channel, and they're using my image, and they're defaming me, and they're using it for profit. So I'm not going to share my image.
I see. All right. Well, as long as you're not holding anything up that would be in any way anything that I would need to refer to, I'll allow you to keep your screen closed at this time. So this is case G47917-01, South of the State of Texas versus Jose Gerardo Elizondo. There was a jury trial in this case on August 28th, 2025. The jury found the defendant guilty, sentenced the defendant to $200 fine, and then there were the court costs that were required. Court has received the defendant's motion for new trial, and you indicated you requested a hearing. And so, sir, this is the hearing for your motion for new trial. You may go ahead and state your argument at this time, sir.
Yeah, well, I just want to move this expired registration citation to be dismissed because it fails to state a cause of action, which relief can be granted. And at the time of the stop, they violated my constitutional rights under the color of law.
All right, so sir, in your motion, you list 3 grounds for the new trial. And you say that it was contrary to the facts, the conviction was contrary to the law and the evidence, and that you were subject to the deprivation of rights under the color of law. And sir, you need to make your argument in regards to how you were subjected to how your rights were deprived.
My rights were deprived because according to the Texas Transportation Code, Section 502.003, no political subdivision shall require registration on a non-commercial vehicle. I don't have a non-commercial vehicle. Like my vehicle is not commercial. And unless y'all think they're all above the Texas Transportation Code, then I want to file to dismiss.
This is a motion for new trial. This is a motion for new trial. The case cannot be dismissed because you've already been convicted of it.
Well, Your Honor, respectfully, who suffered an injury or from an expired registration? Like, who did I hurt?
Sir, this is not a dialogue. I was just trying to clarify that this is we're here on a hearing for your motion for new trial. So you need to state your argument on the record in regards to the grounds for your motion. The prosecution will have a chance to make their argument. Then I'm going to rule. So I just wanted to remind you, this is a motion for new trial. You can go ahead and state any other argument in support of your motion at this time.
Well, Your Honor, I respectfully request that my objection be noted for the record, and I preserve all my rights to appeal. Respectfully,
I'm sorry, sir, what objection?
The motion to dismiss. I'm filing the motion to dismiss on my new trial, but I've stated multiple times how I feel, and I feel like y'all are just depriving my rights.
Anything else you wish to state in support of your motion, sir?
That'll be it.
Response from the state, Mr. Bishop?
Yes, Your Honor. The defendant states his grounds that his conviction was contrary to the law and the evidence. This is an expired registration ticket, and certainly the state had evidence of that. It's my recollection the defendant admitted that during cross-examination. Then he says he was subjected to his deprivation of rights under color of law, and he lists 3 ways in which he alleges that happened. First is denial of due process. There was no denial of due process. He had his due process. He had a trial. He had a jury trial. Second was unlawful and prejudicial actions that materially affected the outcome of the case. I'm not sure what he's talking about there. He doesn't list those. And then thirdly, improper application of the law that resulted in miscarriage of justice. I'm assuming he's saying that the political subdivision made a law requiring registration and they're prohibited from doing that. That's a correct statement of the law, but that's not applicable here. This is a state law, not a city ordinance requiring a vehicle registration. So the state of Texas is not a political subdivision and certainly has the right as a state to make laws requiring the registration of vehicles. So it seems to me the law was correctly applied and the proper law was applied. Nothing further from the state, Your Honor.
Thank you very much. All right, the court has held this hearing on the motion for new trial in this case. The court has heard argument from both the defendant and the state. The court is denying this motion for new trial at this time. Let me write this down. All right, Mr. Elizondo, you do have the right to appeal. If you wish to appeal this case, the next step is to file a notice of appeal and to perfect an appeal bond, which is double the amount of the judgment in this case. And that is due within 10 days of today's date. So the judgment in this case is $286, and the appeal bond is double that.
All right.
So that's going to be $572. You'll need to get that filed and perfected within 10 days if you wish to appeal. If you do not wish to appeal, you either need to pay this in full or set this up for a payment plan within the next 10 days.
All right. And I would contact the court in the next 10 days to decide, right?
I'm sorry, sir. Could you repeat that one more time?
I would have 10 days to decide whether I want to appeal or not, right?
That's correct. But you do have to actually get the appeal bond completed in the 10 days.
Sounds good. Yeah, I would like to wait, and I'm going to look into that.
Case number G 5072501, State of Texas versus Israel Burrell. The charge is speeding going 96 in a 45-mile-per-hour zone. Is the state ready?
State is ready, Your Honor.
Okay. Mr. Burrell, have you received a copy of the complaint charging you with this offense? Sir, you're mute. I can't hear you. Let's see. Have you received a copy of the complaint charging you with this offense? I still can't hear you.
Can you hear me now?
Yes, there we go. All right. Have you received a copy of the complaint charging you with that offense?
Yes, I have.
Do you wish to have that complaint read here in open court?
Yes, ma'am.
Okay. Mr. Bishop, will you please read the complaint?
Clause number G 5072501, State of Texas versus Israel Miguel Burrell. In the name and by the authority of the State of Texas, I, the undersigned affiant, do solemnly swear that I have good reason to believe and do believe that Israel Miguel Burrell, hereinafter called the defendant, on or about the 4th day of July 2025 AD, and before the making and filing of this complaint in the territorial limits of the city of Dalwellington Gardens in the county of Caron, state of Texas, did then and there unlawfully drive and operate a motor vehicle on a public street, to wit, the 3000 block of West Pioneer Parkway, at a speed greater than was reasonable and prudent under the conditions then existing, having regard to the actual and potential hazards, to wit, at 96 miles per hour. The maximum lawful speed at such time and place being 45 miles per hour is provided by the Transportation Code of the state of Texas. My belief of the aforesaid statement is based upon information provided to me by Michael Bass, a peace officer for the state of Texas and or city of Darlington Gardens, who personally observed such offense against the peace and dignity of the state of Texas, signed by Sandra Moss, a credible person on July 22, 2025 before a notary public.
All right, Ms. Burrell, you've heard the reading of this complaint in open court. To this charge, how do you plead?
Not guilty.
You've indicated you wish to waive your right to jury trial and have me hear your case tonight, correct?
That's correct.
And you wish to represent yourself, correct?
That's correct.
All right. Mr. Bishop, you may call your first witness.
Paul Officer Michael Bass.
Officer Bass?
Yes,
Do you
ma'am.
swear you in? Do you solemnly swear that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, please state your full name and spell your last name.
Michael Bass, B-A-S-S.
Mr. Bishop, you may proceed.
Officer Bass, how were you employed on July the 4th of 2025?
I'm a commissioned police officer with the city of Dalworthing Gardens.
And on that date, sir, were you working traffic enforcement in the 3000 block of West Pioneer Parkway?
Yes, sir, I was.
And during your service as a police officer for the city of Dalworthing Gardens on the day in question, did you come in contact with an Israel Miguel Burrell?
Yes, I did.
And did you issue or did you observe a speeding violation
Yes, sir, I
committed
did.
by Mr. Burrell?
That's correct.
Can you identify Mr. Burrell if you saw him again?
Yes, I'm able to see him, and he's a black male, approximately 200 pounds, has a beard.
Is this the same person that you observed commit the speeding violation
Yes,
on the
sir.
day in question?
Yes, sir.
All right, sir. Is the 3000 block of West Pioneer Parkway a public street located in the territorial limits of the city of Dalworthing Gardens, Tarrant County, Texas?
Yes, sir.
And on that day, sir, were you stationary or were you moving?
So I was stationary. I had my vehicle parked in about the 2700 block of West Pioneer Parkway, facing west. So I was conducting traffic enforcement for eastbound traffic on West Pioneer Parkway.
All right. About what time of day was it?
It was approximately, I believe, 1:17 in the morning.
Okay. Now, do you have the ticket in front of you?
Yes, sir, I do.
You can use that to refresh your memory. Are you trained to estimate the speed of a vehicle?
Yes, sir, I am.
And do you remember the defendant's vehicle approaching you?
Yes, it was the only vehicle on the roadway at the time.
And can you tell the court whether you were or were not able to make a visual estimation of the speed?
So yes, we are trained to make a visual estimation. Then we confirm that through audio tones within the radar unit itself, and then a visual representation of the speed.
Okay, and were you able to make a visual estimation of the defendant's speed?
Yes, I was.
And what speed did you believe he was traveling based upon what you saw?
Based upon what I saw, I estimated around 80 miles an hour.
Okay. Are there signs posted on for eastbound traffic on West Pioneer Parkway concerning a speed limit?
Yes, they are.
Are those signs lawfully posted to your knowledge?
Yes, they are.
Were those signs visible on the night in question?
Yes, sir.
And what is the maximum posted speed, or what was the maximum posted speed for the 3000 block of West Pioneer Parkway on July 4 of this year?
45 miles an hour.
All right. And again, you estimated the defendant's speed at over 60,
Over at least 80
at least
at
80.
the time.
Now, can you tell the court whether you used your radar to clock the defendant?
Yes, sir, I did.
Was the defendant coming towards you?
Yes, he was.
Was there any vehicle between your radar and the defendant's vehicle?
No, there were no other vehicles on the roadway.
Okay. And did the defendant have his headlights on?
Yes, he did.
Okay. In regard to your radar, when did your shift start that day?
It started on July 3rd around 7 p.m.
So you were working 7P to 7A, is that right?
That's correct.
And can you tell the court whether or not you tested your radar before the start of your shift?
Yes, so per policy, we're required to test the radar prior to our shift beginning utilizing the tuning forks. The test did not reveal any discrepancies with the radar. During my shift, the radar recalibrates every 10 minutes and does a self-test to identify that it is properly working.
Did it pass all of those tests?
Yes, sir, it did.
Now, when you clocked the defendant's vehicle with the radar, are you sure you clocked the defendant's vehicle and not someone else's vehicle?
There was no other vehicle in the eastbound travel lanes. The setting on the radar was for traffic that was approaching me only. There is an option for it to display speeds for traffic going both directions, but I had it specifically set for traffic coming at me.
Did it register or give you a verbal clue? Well, let me rephrase that. Did it give you a set speed that it clocked the defendant's vehicle at?
That is correct. The speed was 96 miles an hour. There is an audible tone that emits from the radar unit. As the speed increases, the pitch increases also. So I verify the pitch with the reading on the radar to determine the speed of the vehicle.
Was the pitch on the radar when it clocked the defendant, was it consistent with a vehicle that was traveling at 96 miles an hour?
Yes, sir. It's a very high pitch sound.
And your radar showed it was 96. Is that correct?
That's correct.
Okay. And what did you do after you clocked the defendant's vehicle?
Made a traffic stop. Mr. Burrell pulled into the Walmart parking lot. Made contact with Mr. Burrell. I immediately observed him to be agitated. I told him, well, first of all, I told him who I was, who I worked for. Told him that the traffic stop was based upon his speed being recorded at 96 miles in a 45 mile an hour zone. His response to me was that I was tripping.
Okay. Was there anybody in the car with him?
I did not observe anyone.
All right, and I'm assuming at that point you issued the citation. Is that correct?
I did issue a citation. Mr. Burrell refused to sign for his promise to appear. I then attempted to hand him the citation. He refused to accept it. I placed the citation on his dashboard. Once the traffic stop concluded, Mr. Burrell took the citation and threw it on the parking lot of the Walmart.
Okay. All right. The Does the violation date and time, does it show on the, or do you remember when the violation was recorded on the ticket, what time it showed?
I do not recall, sir.
Would you agree that it was 4:14 in the morning?
So this citation was a second citation that I issued because the first citation that was issued, I had incorrectly placed a 40 mile per hour instead of 45. So I requested that the court dismiss the citation, and I reissued the citation based upon the complaint that you have today.
Okay, so when approximately did the violation occur?
Probably around 1:17 or so in the morning. And that's based upon my review of my body camera.
Okay. And then the citation that we have that's the subject of this case was issued at 4:14. Is that right?
It was issued several days later after I had consulted with the court and was given information on how to proceed with dismissal of the initial citation and the reissuance of the second citation.
All right. Okay. Now, can you tell the court on the date that you issued the citation whether you checked your radar after you had clocked the defendant?
I do not recall, sir.
Did you check your radar at the conclusion of your shift?
Yes. And again, the radar unit does a self-calibration every 10 minutes also.
Okay, well, let's talk about that. Did you notice or get any signal from the time that this stop ended and you'd issued the citation until the end of your shift that the radar was not functioning properly?
No, sir.
What test did you give it at the end of your shift?
An additional tuning fork test.
And did it pass that test or fail
Yes,
that
sir.
test?
It did.
It did what?
It did pass.
Okay. Officer, at the time you observed the defendant in the 3000 block of West Pioneer Parkway on July 4, 2025, is it your testimony that he was traveling at a speed that was greater than reasonable and prudent under the conditions that existed at that time?
Yes, sir, I do.
Why do you say that, sir?
Based upon my observations and the recording on the radar unit.
Now, West Pioneer Parkway has streets that run perpendicular to it. Is that correct?
Yes, sir.
And so there could be other traffic entering West Pioneer Parkway from those streets. Is that correct, sir?
That's correct.
And in your opinion, officer, was the fact that the defendant was traveling 96 miles an hour, would that endanger someone that was possibly entering West Pioneer Parkway from a perpendicular street or intersection?
Others, and my concern for Mr. Burrell's safety also.
Right. I pass the witness.
All right, Mr. Burrell, this is your opportunity to ask this witness questions regarding this case.
Okay. Absolutely. So my first question is, when you came up to my car, I wasn't irritated when you first came up. I asked you a simple question. You didn't show me your radar.
Objection form.
Okay, objection sustained. Sir, you need to ask one question, not make a statement. And if you ask a question, you've got to wait and let the witness answer.
Yes, ma'am. So my thing is, okay, when he pulled me over and he said I was doing it, and
Don't speak to me.
Well,
this is your time to ask him questions.
Absolutely. So when I asked for a supervisor, officer, why did you walk away to your cruiser and didn't acknowledge me?
I don't recall you asking for a supervisor, and I am the supervisor on the shift.
But I did ask you. So That's it for now.
Action form.
Wait, I'm sorry. You said that's it for now. Does that mean you have no other questions?
Oh, absolutely. I would like to testify.
No, but do you have any other questions of this witness?
No, ma'am.
Okay. Any further questions, Mr. Bishop?
State rest, Your Honor.
Okay. So, Mr. Burrell, that's all the evidence the state is going to present in their case in chief. Remember my earlier warnings. The state has the burden of proof. They must prove each and every element beyond a reasonable doubt. You have no burden of proof. You don't have to offer any testimony. In fact, you have a Fifth Amendment right to remain silent. Do you wish to waive that right and testify?
Yes, ma'am, I would like to.
Okay, please raise your right hand. Do you solemnly swear that the testimony you'll give, is that your right hand? I can't see your hand.
Yes.
Isn't that your left hand? There we go. All right. Do you solemnly swear the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right. You don't have to ask yourself questions. You may just go ahead and testify.
Oh, absolutely. So before he stopped me, which was trying to tell him, but like I said, he was not acknowledging me. I was doing Lyft full time. Literally before he pulled me over at nighttime, early in the morning, I just dropped the passenger off around the corner in that area before me. And I'm not from Arlington. I don't know the areas like this. So after I dropped the passenger off, I was low on gas. So there was no way I would be able, 2013 Hyundai, 147 horsepower. There's no way my car would go that fast. I was heading home. My thing was on E because I was driving for 12 hours, doing Lyft that whole day. I was heading home, but I had to go get gas. You see what I'm saying? So why would I be going that fast in an area I don't know, early in the morning, while I'm heading home and I'm low on gas? And my car don't even go that fast. And I ain't ever went that fast. And him to be a peace officer, all I want is peace. All I do is abide rules. All I was doing was working that whole day. I ain't ever went that fast. And for him to say, it was a visual thing. Okay, why didn't you show me the radar then? Why didn't you give me your supervisor saying I didn't say that when I did acknowledge you and ask you? That's all I have to say.
Cross-examination, Mr. Bishop.
Mr. Burrell, did you have a passenger with you?
No, ma'am. No, sir.
Okay. And the officer says that he clocked you at 96 and a 45 and visually observed you at over 80.
Mm-hmm.
How fast do you say you were going?
I was going the speed limit. I promise you. Especially early in the morning like that, I ain't ever went that fast. I don't even go that fast on the freeway. I barely go 70. In the residential, like, come on now. I ain't ever went that fast. And if I could call my friends and find, they'll tell you, why are you going so slow? So 96 said
Objection, non-responsive.
Yeah.
Objection sustained. Sir, just answer the question, please. All right.
Yes, ma'am.
So he's clocked you at 96. You say you were going the speed limit, which is 45. So it's your contention that his radar has made an error of 51 miles per hour.
Absolutely.
Is that right?
Absolutely. And I just dropped the
What facts do you base your statement on that you were going the speed limit?
Because I just dropped the passenger off and it was early in the morning. And besides, like I stated, I was heading home, but I needed gas. I was heading home after my last drop off. That's the truth. I ain't ever went that fast.
You were driving a Hyundai Sonata, is that correct, sir?
2013, yes, sir.
White in color?
Yes, sir.
And you were eastbound on Pioneer Parkway, is that correct?
I believe so. Like I told you, I wasn't familiar with the area. I just moved to Arlington.
Okay.
But I've been in that area plenty of times because I live close over there.
Did you refuse to sign the ticket?
He never asked me to sign the ticket. He did give me the citation. I do agree. I did throw that, but he never asked me. Even when I went to the court, she was like, "Did he ask you?" I was like, "He never asked me. He just handed and walked to his cruiser. I promise you." He handed it to me and walked to his cruiser, and then he would ask me to sign nothing. That was the first citation I ever got. And he never asked me none of that. Can you sign this?
Did you throw the ticket out the door?
That part I did.
Why?
When he walked to, because he walked to his cruiser when I asked him to bring the supervisor. And I didn't know he was the supervisor, but when I asked him, like, "Can you bring a supervisor?" He walked away. That's when I did that. Yes, I did. He told truth on that part. And that was wrong for doing that.
Were you angry?
After he refused to give me a supervisor.
Were you angry?
No, I wasn't angry. I was a little upset because he wasn't acknowledging me. Trying to listen to my story when I was trying to tell him what I was doing. I'm trying to tell him this. I just finished this. Can I get a supervisor since you don't believe me? And he just walked away. He didn't give me no attention. He knew about
You heard him say he was the supervisor, didn't you?
Yeah, now. But at that time, he would not acknowledge me.
Did you ask to see the radar?
I haven't asked to see the radar. I asked to see the supervisor because I know I wasn't going to 96 and 45 when I
You
just
say you did or did not ask to see the radar?
I did not at that time.
Okay, so all of that, you felt justified in throwing the ticket out the window?
Yes, sir. After he walked away and then acknowledged me to bring a supervisor. Yes, sir. But he did not ask me to sign it. If he would,
but in regards to this trial, you've had the complaint read to you, is that right? And you're aware of the charges, is that correct?
Yes, sir.
Okay, pass the witness.
Do you have any further testimony, Mr. Burrell?
No, ma'am. That's it.
Okay, do you rest your case?
I rest my case.
Anything further from the state, Mr. Bishop?
Nothing further, Your Honor.
All right, we'll proceed now to final argument. Mr. Burrell, since the state is a burden of proof, they get to go first. You may make your argument, they may rebut. Go ahead, Mr. Bishop.
Yes, Your Honor. The officer observed the defendant in the 3000 block of West Pioneer Parkway traveling at a high rate of speed. He visually estimated that at over 80 miles an hour. And the actual speed is confirmed by radar was 96 miles per hour in a 45 mile per hour zone. He's identified the defendant, he's identified the vehicle, and to believe that the defendant was not speeding, you would have to accept that the radar made a mistake of over 51 miles per hour. And the officer made that same mistake when he had made the visual observation. And the defendant is the only vehicle on the roadway going east. Based upon the officer's testimony, the state would respectfully request that the court find this defendant guilty as charged in the complaint.
Mr. Burrell, you may make your final argument.
Yeah, I'm gonna make my final argument. For him to say what he had to say, saying it was a visual and then he check it and then saying he didn't check until the end of the shift, like that's crazy to me. Like I said, I tried to explain to him I was doing lift. I explained to the bishop that I was doing lift. I just finished. I was out of gas. So like I said, I was following the speed limit. That's all I have to say. I ain't got no recording. And even when I was doing lift full time, especially in that, like I got over 2,000 drives with lift. So if I ever drive perfect rating, I ain't had no complaints out of 2,000 rides. Ain't ever spared nothing with them. And even if I had them in the car when he pulled me over, that would have been my witness. I literally just dropped him off around that corner. So that's my last argument I have to say. But I don't even drive that fast on the highway. Ever. So especially at 3 a.m. or around that time, wherever, early in the morning. Come on now.
Does that conclude your argument?
That concludes it.
All right, Mr. Bishop, anything further?
No, we're not saying that he put any Lyft passenger in danger. No one's saying that. He had no passengers with him. And his past driving history is not an issue. I'll take him in his word for that. We're just saying that on this particular occasion, he was going too fast. and the evidence proves it.
All right. In case G 5072501, style of the state of Texas versus Israel Burrell, the court has heard the evidence and the testimony in this case. The court finds the defendant guilty of the offense of speeding going 96 in a 45-mile-per-hour zone. Court assesses a fine of $200. Court costs are $134. The total is $334. This will be due within 10 days of today's date. Now, sir, we are a court of record. You do have a right to appeal if you wish to do so. The first step is you need to file a written motion for a new trial within 10 days of today's date. If you don't wish to appeal, you either need to come in and pay this in full or set it up on a payment plan within 10 days of today's date.